Hello, my name's Hayley Lorimer. I'm Director of Membership at the Federation of Master Builders, and welcome to this FMB webinar on the 3rd of November 2020. I hope that everyone watching is well, and thank you for attending today. This is the second webinar in our series of 4 for this autumn on contracts. If you missed the first one, that's available on the website, on the FMB members area of the website, and we have a new website being launched tomorrow, so if you want to go and visit later in the week to have a look around the new website and find the webinar recordings, I'm sure that will be interesting for you. So before we get started though, I'd just like to acknowledge that we go into a month-long period of lockdown again from Thursday. I'm sure that members watching will be aware of the Prime Minister's announcement on Saturday, and he specifically mentioned construction work and that should continue. And we have had a few queries from members about work in people's homes and whether that can continue, which it can do, provided that it can be done safely. And I just wanted to flag up that there is guidance on that on the FMB website about working safely in people's homes. I can post the link to that in the follow-up email as well, which might be helpful. We've also had quite a bit of feedback from members about the necessity for builders merchants to stay open as essential suppliers during the lockdown period, and our Chief Executive Brian Berry has been working with the Construction Leadership Council to make sure that the government gets that message that materials have to keep flowing during the period of lockdown so as not to hold work up. So that's by way of an aside, really. That's not the matter in hand for today's webinar, although it will have an effect on contracts, I'm sure. So I'd like to introduce today's speaker to you, who is Sarah Fox, the 500-word lawyer, who's going to be talking about the bare minimum that you need to put in a contract and clarifying fuzzy edges, which sounds fascinating. So I'll hand over to you now, Sarah. Thank you.
Thank you, Hayley, and I hope you can see my slides. I hesitate to show slides as a lawyer, but I think there are some principles that are easier to show and demonstrate by showing a set of slides to you. So what I want to look at today is the bare minimum. So what the very limited amount that you need to create an actual contract is in law, because there are lots of things that we like to have in contracts, but not all of them are absolutely essential in the eyes of the law. So I wanted to go through that. Now, if you missed session 1, what you'll find is that we looked at how you can create simple contracts. And essentially, the purpose of simplifying contracts is to create confidence in you and in your clients, to safeguard your business, and to avoid avoidable disputes. Now, you can't avoid every dispute, but what you can do is avoid some of them. And simple contracts are really useful to do that, which is one of the reasons why we ended up simplifying the FMB suite. Now, your contracts really need to clearly demonstrate to your client that you understand her needs, you're competent and trustworthy, and what she can expect when you work together. See, your client may never have been involved in a project before, particularly if you're dealing with a domestic client. So you need to deal with some of the myths that they've got, maybe from TV programs, and manage her expectations of the process as well as the product. Your contract ought to be robust and legally effective, one that both of you can read, use, and understand. Now, quite often contracts are created by a mixture of copy and paste, absorbing information from other people, and we can sometimes get this sort of bingo approach to terms and conditions where we have lots of jargon, which looks all very eloquent and very clever, but actually is pretty much meaningless in a lot of respects, and in some cases downright dangerous. This set of bingo terms I copied off the internet from various contracts, but also things that I've come across regularly that people insist on padding their contracts with, as if it was some sort of fluffy cushion that you needed to make really full. Some of these are even American terms which have no place in a contract used in the United Kingdom at all. So if you do come across these, be very careful and be very wary of them. And whatever you do, please, this is not a slide that I want you to copy the content from. This is the one that I want you to avoid the content from. So Samuel Goldwyn Mayer, who ran Metro Goldwyn Mayer, said a verbal contract isn't worth the paper it's written on. Now, it's not to say that in English law you can't have a verbal contract. You can. The difficulty with a verbal contract is that your understanding of what you've agreed and your client's understanding of what you agreed aren't going to meet in the middle. You see, we know just from witness statements in crimes that actually people remember much more what they've been told than what they've said. So as a builder or as a member of the Federation of Master Builders, you may remember what your client has said to you, but not what you've said to them. So verbal contracts mean that our memories have to be totally aligned if we're going to rely on them. And that's a difficult thing to do, particularly once you've fallen out. So it's really important that we have some form of written contract. Now, contracts are tools to help you do business, in my opinion. However, you may find that contracts don't have that particular role. So, Hayley, could we launch the first poll, which is to look at what you think the primary purpose of the contracts you see in your business are? So what is the primary function of the contracts you sign? Is it to safeguard and enforce legal rights, to give you a remedy if there is a dispute, to make sure that you've got rights and your business is protected? Or is it to manage the project and to manage the client and the builder and the tradesman and the process?
So hopefully everyone can see now that 81% of attendees think that safeguarding and enforcing rights is the primary function of the contract. So
to be honest, I've asked this question a lot of times, and that's roughly where I think we've got to. But contracts are more than just for safeguarding and rights. They're for managing the project, for managing change, for managing risks, for encouraging behaviours that we want to see and discouraging behaviours we don't want to see. They're to protect information that needs to be shared. They need to prevent problems before they arise. Managing the project is just one part of that, and so is safeguarding remedies. The balance has gone very much towards the legal, whereas in fact contracts can actually be a much more powerful tool when it comes to managing the project itself. So you could write your own contracts, but if you use the FMB suite, it's going to be quicker, simpler and safer than writing your own. If you write your own, unless you've got a really good basis, then unless you really understand the law, the chances are you're going to add something you don't need and miss something you do need. So get a really good guide to understanding contracts. But in this, we're going to look at the very bare minimum. Now, contracts, you'd have thought, I'm a contracts person, so I might be biased about this, but it was a surprise in one of the cases recently to do with letters of intent, where the court heard a professional project management consultancy, a really big name, effectively treat contracts as a dispensable luxury. Now, this is a grade 2 listed building, a Georgian country house called Benjeo Hall, and that ended up in a letter of intent and contract scenario. Letter of intent was sent, full contract was going to be agreed. Well, they never quite got round to it. But at no time would the judge say that the contract in that was a dispensable luxury, because the simple contract they had didn't even really cover the bare minimum we're going to talk about in this. So contracts are really important. And I'll show you some of the examples of cases and projects where the contracts haven't really covered the bare minimum we're going to talk about today in enough detail. So what do you think the bare minimum you need to create a certain contract is? Well, let's find out what you think. So, Hayley, you can fill more than one of these in. I recommend that you fill at least 2 of these things in terms of what the bare minimum the law requires to create a contract. So that's not what you'd like to have in it, because trust me, all of these things should be in a contract. But if you miss some of these things out, can you still have a legally binding contract under English law? This is not a poll I've done before, actually, so I just was interested in what you thought was necessary. So works, excellent. 93% of you said works is essential, and it is. 57% of you said people was essential, and they are, and the 43% said who didn't think it was, well, you're going to be in trouble. Price, timescales and quality, well, let's see. So the bare minimum, what we might think of as the bare minimum is who is carrying out the work. So really important, Generally, this will have been dealt with in a form of emails, telephone calls, letterheads, proposals, estimates and offers. Generally, there's less debate about people unless they're part of a big multinational group and we've got the wrong division. But really important, and we'll come to people, particularly when it comes to domestic householders. We also need to think about what goods, works and services. You can't just have usual services for the usual fees, because usual services doesn't mean anything to someone else. You see, certainty doesn't just apply between the two people who are involved in the contract. It applies so that an outsider, someone like me, a contracts reviewer or a judge or a tribunal or an adjudicator, can see what the parties were meant to do. Now, we talked about price. Surely price is really important. We need to know how much it's going to cost. The client needs to know how much they're going to pay. You need to know whether you're going to make a profit. The client also wants to know when it's going to finish, when it's going to start. Do they have to clear out? How long the whole project is going to, or is at least expected to take. Client also might be really interested in the quality or performance standards that you're going to get involved in. And the client actually probably has a clear outcome why they're doing this project in the first place, because they're, let's face it, they're handing over cold hard cash. They're going to want something out of this. The reality, however, is whilst all those things are highly, highly desirable and very important, that's not what the courts consider. Bare minimum you need to create a certain contract in English law are people and works. They must be expressly and clearly set out in your contract. And the reason why we don't need the other thing is many of those things can be implied by acts of parliament or laws or statutes or court decisions or cases in the UK. And we'll talk about all those other things in future sessions so that we can really dig into what would be the position if your contract said nothing. If your contract says nothing about the people and works, you probably don't actually have a contract, because there's just not enough certainty for the courts to decide what should be being done and by whom. Now, we're pretty good at getting this bare minimum into our contracts, but it's still really important that we understand how we approach those properly. So let's have a look at the who, and I don't mean the rock band, I mean the parties. Now, this is legal terminology. The parties doesn't mean cake, it doesn't mean party games, and it doesn't mean going around to someone else's house, which of course you're not currently allowed to do. So the parties for the purpose of the FNB suite are the client and the builder, and they're almost always on the FNB suite on the first page because the parties are really important. We need to record precisely who is carrying out the works, their address or registered office, and a contact telephone number and an email if we've got one. So really important that we specify precisely who the client and the builder are. In English law, you're free to contract with just about anyone. The exceptions are people under the age of 18, known as minors, anyone who is incoherent through the use of alcohol or other substances, what we might call as drunks or addicts, and people who don't have mental capacity. Now, when it comes to the client, if you're working on a project in somebody's home, you need to make sure that everyone who owns the home is a party to this contract. So it could be a couple, it could be multiple people, or it could just be the landlord or owner of the house. And check if you're concerned. Ask them to provide you with evidence if you're not entirely sure that they own the home, because you really important that you don't do work that is paid for by a tenant but on a landlord's property, because the works that you do under property law in England will belong to the person who owns the land, not the person who's renting it. So you could have done works for a particular person, but the goods, the completed project is owned by the landlord. Well, the landlord doesn't need to pay you. So you really need to make sure you've got the right remedies against the right people. And when it comes to working with a limited company, if this is a contract for commercial work, then make sure that you've got the right company. You can do a really quick free search on Companies House, put the company in, make sure you've got their number and registered office. The company number is the unique identifying fingerprint of a company. So it's really important. They can change their name, but they can't change their number. So get that information into your contracts, and then you've got a really crisp, clear understanding of who is signing. But why do you have to bother to get the parties right? Well, it's very quick and easy and free generally to clarify the details of the parties. Once you know, then you know precisely who you're dealing with and who should be paying and who should be carrying out the work. There are really serious consequences if you get this wrong, though, because it's very difficult to bring proceedings against the right company. And my book, The Small Works Contracts, tells you what happens and gives an example of what happens when you've got the wrong company name. It can be very costly to bring a case against the wrong company, because it could just get thrown out. You might have to start again. And there's also a legal issue called privity of contract, which basically means once the party is named on the contract, that's it. Nobody else can be a party to the contract. Nobody else is in there. So if you name the wrong company, then the company you were hoping for isn't actually contractually bound. They don't have to pay you or give you access or whatever. So it's really important that you get it right and you know precisely who you're dealing with. Of course, once you know who they are, you also need to make sure the right people sign the contract. Signing a contract is the best practice to show that both parties have agreed the content in that contract. You can accept a contract through other means. So you can send a text, do a handshake, send an email. You can probably send them an emoticon if you really want to. The FMB contracts have been designed to be signed electronically, so it's dead easy. Nobody has to print, sign and scan. But if you can get it signed, it's really good practice as a brief administrative step before you start work. Always try and get your contract signed before you start work. So electronic signing is permitted under English law pretty much for every contract. The only exception is deeds, and there are some nuances to do with accepting contracts that are electronically signed as deed. So get it signed before you start work, and make sure the right people are named as signatures. Now, in terms of limited companies, any director or company secretary can sign, or any other authorised person. You generally don't have to investigate whether or not they've got authority to sign, because if you deal with them in good faith and they've signed, then you can treat that as an acceptable signature. So don't worry too much about the niceties. So once we've got the parties done, which is pretty quick and easy to sort out, we need to look at the what, the goods, works and services. So it's really important to define the scope clearly. Now, I know we're not talking about buying cars, but imagine if Hayley was going to sell me her Mark II Jaguar. I don't even know whether Hayley has a car at all, but for the purposes of this, let's just assume she has 2 Mark II Jaguars. I don't know that. I only think she's got 1. Now, it turns out that I've asked for her Mark II Jaguar. Now, she has 2, one of which I'd be quite happy to own because it's roadworthy, the one on the left, the first one shown. The second one, that's not going to pass a test. I'm going to need a tow truck to pick that one up. But defining the scope clearly means that both Hayley and I knew what I was buying, because the price that I might agree for the car on the left is certainly not the same sort of price that I would agree for the car on the right. So getting the scope clear is really important. Now, this is just a kind of an example just to think about, but your small works contract needs to be accurate. And that means describing the works to make sense to both Hayley and me, or the client and the builder and other people, so outsiders can see exactly what you're going to do and what your client has asked for. You see, if you don't have a clear scope, how can you possibly decide that your price is fair one? If it's a piece of rope, how long would you charge for a piece of rope? Well, obviously it depends how big that piece is. If you don't know what the scope is, how can you assess progress against a schedule? Because if you don't know what 100% of the works looks like, how can you tell that you're halfway through? Because you can't actually see the end. How can you determine what a change is? Now, that is really important. If a client can't read the document that you've called the scope of works or the goods, works and services you're going to provide and say, oh, you didn't include for X, then how will they know that that's an extra? Clients can make all sorts of assumptions that are really dangerous and costly if you don't have a clear scope. And then how can you work out when you've finished it if you don't know how long that piece of rope was? So being clear about the scope is really important, not just for the scope purposes. Now, this was a case to do with a dispute relating to a project to carry out works to a nursing home. So this both had a person's accommodation, it also had regulated accommodation as a care home. And what the court said was there were virtually no reliable documents to provide evidence of what had been agreed between the parties and between whom. Not only did they not know what works were being carried out, they didn't know when it was going to be paid for, who was paying for it, because there was a limited company, a tenant, an owner, lots of different people who might have been involved. And they couldn't then work out when would be a good time to complete, because court couldn't even work out what a reasonable completion date was, because they couldn't work out what the works were. So this was a really good example of how sometimes we can allow the project to get ahead of us. And actually just taking some time out to describe it in a way which was clear and crisp to both parties would have really helped that project to avoid a really quite serious dispute. So in the FMB suite of contracts, there was all different ways that we put in information and scope. So this is an example from a short contract, and it's to do with, whether or not they're going to stay in the business. This is kind of a bit more of a refinement. Are they staying in the property? Are they going to have restricted access? And it also talks about what isn't going to be included. And the tasks which are not your responsibility are also really useful to list, because a client may assume that you're doing it if you're not really clear. Now, this was another case to do with getting the scope right. The client had actually asked for a swimming pool. It was meant to be 7'6" deep, and it turned out only to be 6'6" deep. Now, that foot made all the difference, and the client wanted to rip it up and start again. But actually, the importance of writing a scope is actually you follow it. This went all the way to the Supreme Court, cost hundreds of thousands of pounds in legal fees, because although the scope had been clear about the depth, the contractor had not followed its own scope. And it's really important. If you normally build swimming pools at 6'6" deep and the client asks for something different, you have to make sure you've got a way of recognizing that and logging that. It was an extremely expensive mistake. The reason it's important to define our scope is also to help with changes, because a change is only work that is not included in the original scope. If your scope is a little woolly, well, determining whether something is a change is woolly. So it's really important that you can define the changes. This is another example of a project, and this was a multi-million-pound development in London, an old GPO building turned into 3, shall we say, luxury flats. Now, Mr. Mackay, who owned the one on the right, was a barrister and legal advisor and really should have known better. He had a contract with his contractor, tick. However, the contract had a very clear mechanism saying what counted as a change. And the client actually refused to carry out its own contractual mechanism. So the problem was this 5-story luxury house in London worth millions of pounds ended up in a major dispute before the courts. The contractor in the end was paid a couple of £1 million by way of damages, but the client lost so much in legal fees that it actually had to sell this house. Now, the change mechanism and the scope could have been clearer at the beginning. There were so many things that hadn't been sorted out before they started work on this project. And it does appear that the client was a bit of a beast of a client. He was constantly changing his mind. He didn't really like to follow his own contract. He was a bit fast and loose with his contract. Now, maybe a simpler contract might have focused his attention more, but maybe he was just the sort of client that actually a bit of discussion beforehand could have helped kind of raise the alarm that this was going to be a really tricky client. The client didn't do well out of this project, but neither did the contractor, because they ended up having to sue to get their money. So good, clear contracts can clarify what requires to be done, what is still under discussion, and therefore maybe if that's a big chunk of work is still under discussion, the parties need to kind of decide whether or not they should be contracting at that point. Because I think the contract ran away with the project and the project ran away with the contract. So it's really important that we understand the role of changes when it comes to a scope. So the other thing that a clear scope should do is to define exclusions from the contract, what you're not doing. And this may be because it's outside your expertise and outside your competence. It may be because you expect your client to get this specialist assistance from somewhere else. It may be that it's their responsibility to carry out these sort of tasks. And being really clear is helpful, partly because it helps the client to understand what they have to do, and partly because it really does help avoid disputes. Now, this was a really sad case in London from about 2014, where the tenants of the ground floor flat, this was a 2-storey building, semi-detached property in London, with their landlord's permission, appointed an engineer as well as a contractor to dig out their basement to make it living accommodation. They were expecting a child. Now, the tenant of the first floor property woke up and saw daylight coming through their wall. And after forced evacuation, it became apparent that this property was going to collapse and was demolished within, I think, a couple of days of the first cracks appearing. Now, I'm not a property expert, but I can tell that given that the walls are no longer matching up to the roof and there's daylight running through the building where there shouldn't be, this is quite a serious issue. Now, it went to court because the role of the engineer wasn't very clear. The engineer had not been appointed to supervise the works, but their role in terms of how much they should have told the client and what their obligations were kind of a bit fuzzy. And actually, if they defined exactly what they were doing and what they weren't doing with much more clarity, the client might have realized that there was a gap. They were letting a company without a background in basements, to be fair, take on what was an extremely risky project without any supervision. And the contractor had in fact lied to the local authority about who had inspected the underpinning. So it was really serious. They lost everything in this case, and it was a really horrible case. But actually, by defining what the parties were going to do more clearly, it would have been easier to see the gaps in these projects. So clarifying the role is really important. Both the role of the contractor, referred to as our in the FMB things because you're members and your builders, as well as the client, referred to as you in the contracts. Often clients think the only thing they have to do is pay you, and that's not entirely true. They do have to give you access. They do have to give you information. They have to seek approvals. They have to get specialist expertise. They have to get planning consent or building regulations approval or whatever the contract says. And one of the things we wanted to do when we amended the contracts was to make sure that those are big chunky sections clarified their roles properly, rather than leaving it sort of a bit of a scattergun approach throughout the contract. So it was difficult for an unsophisticated client, someone who hasn't done construction projects, to actually draw out what they need. Because the purpose of plain language and simple contracts is that you can find your obligations as well as understand them when you do find them. I think we've all come across contracts where we're flicking from to and fro, not really being able to find what we need. And the purpose of a plain language or simpler contract is to enable anyone to pick it up and quickly find the information they need and act on it. So we wanted to make things clear and simple, because it's no point just having a long, complicated contract and saying once they failed, oh, you didn't do what we asked you to do. That's a legal remedy approach. We wanted to take a project management approach where we made it really clear upfront what they had to do. So the final poll is looking at working for free. So simple question, do you need a contract if you're working for free? Imagine a friend, your closest, dearest friend, godmother, uncle, rich neighbour asks you to do a little job for free. Should you have a contract?
It's quite an unequivocal answer there, Sarah, so I'll just share that on the screen for you.
So I'm not entirely surprised, and it may be that it's a loaded question coming from a contracts expert, but obviously there have been occasions where people fail to follow this advice. And there was a case a couple of years ago to do with a landscape architect, and she was talking to her friends, and they'd engaged a celebrity designer to look at landscaping their project. And the celebrity designer had quoted £175,000, which the client said that was well above their budget. And she suggested she get her landscape contractor to do the work. She'd do the design for no fee, and they would do the works. Now, the contract was done, the garden was landscaped, but it became far more expensive than the client had wanted. And the client had said that their budget was only 130,000, and it came out as more than that. Now, this clearly is just a sample of the garden, but there's a lot of work involved in terracing this plot. It went to the Court of Appeal. So working for free cost them a lot of money, both of them, because they had to go to court to establish what their obligations, what's their rights and remedies, what should have happened on this project. The court actually held there was no contract, but there was just a duty of using reasonable skill and care. That then had to decide whether or not she'd breached that duty. So not having a contract costs them a lot of money just in establishing what their roles were on this project. So even if you're doing what looks like it's going to be a small project, it's really important. Small projects don't mean small risks. They don't mean small damages if the project goes wrong. And this was a really good example of how we can learn lessons from somebody else's mistakes. Don't do work for free without a contract, even if you think it's going to be small. Small projects tend to morph into bigger projects. So be clear, even if you're doing it for free, make sure you've got some sort of contract. It helps to know who's got rights and remedies, whether or not you can safeguard your business, and it clarifies what you're actually going to do and what their scope was. Because one of the arguments was that she had agreed that their budget was 130,000 and she said she hadn't. And that would have been really clear if they'd written a scope. So that's all I want to talk about in this session so far. So if I stop sharing and we can go to questions, Hayley.
Thank you, Sarah. So there are a couple of questions for you. And I just wanted to add as well, because we run a dispute resolution service within the FNB for members, and we can offer mediation between our members and their clients. And lack of clarity around the scope of works is one of the biggest issues that causes disputes to come into the FNB, where the client was maybe expecting a Rolls-Royce or a Mark II Jaguar, but was actually paying for, something like a Ford Fiesta. So it is a big issue. Yeah.
And it's really easy, because if I said to a professional, can you come and decorate my lounge? I know what I think and they know what they normally do, but those two don't necessarily meet in the middle. And we, on construction projects, we have those sort of things multiplied for every single little element of this project. So it's really important that we have clarity. I'm not expecting you to write all the nuts and bolts in, but just making it really clear, so somebody else who doesn't know anything about the background or the chitter chatter you've had can read it and go, oh yes, I know that they've done everything they promised to do.
Yeah, great. So Steve has asked a question, and it's another technical question about the actual format of the contracts, because he's asking about the boxes in the FNB contracts for drawing schedule and list of works are too small. Can they be expanded upon so they can add more information into the contracts? So I think maybe you and I need to go away afterwards and look at improvements that need to be made to the actual format of the contracts, because a member asked in the last webinar about the ability to upload logos as well, didn't they? Yeah. Company logos. So we've obviously got some work to do to make those a bit more user friendly. I think even though they are a big improvement on what we had before, there's always more that can be done. So thanks for that, Steve. Lisa's also asked a question saying, if we carry out additional works that are clearly not in the contract but requested by the client while works are in progress, if we fail to supply costs prior to carrying out these works, should they not be liable for a reasonable amount to carry out these items?
Yes, and they would be, because they would normally come under a change mechanism. So if you've got an FNB contract, it has a change mechanism. And if the client asks for extra works which weren't in the original scope, then you're entitled to be paid. Now, it's a counsel of perfection to agree how much they're going to be, how much you're going to be paid, and how long extra it might take if you do those works, so that the client can make an informed decision about whether, yes, they really do want you to change the works. But we know that projects get ahead of all those sort of administrative decisions, so that if they've asked you to carry out works, you're not going to be doing it for free, because nobody would. You get no benefit from doing it. So if it's a clear change, it's really important that you make it clear that you think it's a change to the original scope, so the client is under no misunderstanding that they're getting it for free. So you should always say, thank you for your instruction. That is a change to the original scope. It means it could take longer and cost more. Do you still want to go ahead, and do you want to agree this first? It may be that you can't get it agreed, but you would get a reasonable price. And we're going to look at price and time in the next session anyway. So come back to that session and we'll talk more about what reasonable means and who gets to determine it. The difficulty is that if you don't agree a price and you end up falling back on a reasonable price, your view and their view may not match. And the only way then to resolve that is to take it to either mediation, adjudication, or court to get that determined.
Okay. So a related question from Kevin, because you're talking about the reasonableness or otherwise of the cost. Kevin's asking, what defines a reasonable standard? I guess he means the sort of quality of the work and the standard of the workmanship, and how to define that.
Yeah, and that's a really tricky question, because poor quality is a really big issue when it comes to cases, because poor quality lasts a lifetime of a project. Whereas, going a little bit over in terms of time or cost, you can kind of get over it fairly quickly, but poor quality does last. So it's one of the big issues when it comes to clients. Quality standards can be defined in a number of different ways, and we do talk about quality in one of the next sessions, because there's essentially two different ways of looking at it. How much skill and care you put in, a bit like the architect, the landscape architect case, and that's to do with services. So we tend to look at services as being reasonable skill and care. We tend to look at products and components being fit for a specific purpose. So a chair being suitable to sit on, a Jaguar Mark II being suitable to drive, and windows, being window watertight and all that kind of stuff, and maybe having U values. But quality can be defined as part of the scope, and it's really important you do, because reasonable quality is really difficult to put your finger on and is not really very objective. It's not a yes or no. And ideally, you want quality to be a yes, it does what it says on the tin, the Ronseal effect, I suppose, for projects. So we will talk more about quality, but reasonable, the problem with reasonable time, reasonable cost, reasonable quality, if you don't write them in, then you're relying on somebody else to tell you what you should have done, by which time it's kind of too late. So that's when we look at a contract as being a tool for legal enforcement rather than managing the project. Because if I said to my kids, you've got a reasonable time to tidy their bedrooms, my idea of reasonable time is before the sun goes down today, although to be honest, it has already gone down today. But their idea is probably before they leave home. So, we have to have some sort of objectively measurable, certain thing that we can point our finger at. So the more you can be precise about the standards that you're going to achieve and the finished product is going to achieve, the better it is for both of you.
Okay, that's really clear. Thanks, Sarah. Rory has asked a question about if a contractor starts to undertake work without signing the contract, does the fact that they've started the work mean they're in agreement with the terms of the contract, even though they haven't signed it?
Ooh, well, tricky question. Contract formation is a big problem. So it depends on whether a draft contract has been sent between the parties. If you've kind of just mentioned we should have a contract, then there isn't anything that you can actually state is the basis of your contract. If you've started to do works and you've started to get paid and you're on somebody's property, then you will have a contract. But we're looking now at an oral contract and it's not worth the paper it's written on, to coin a phrase. So if you've been sent a contract and you start work, but you haven't said, I don't agree with this contract, then the mere fact that you've started work in legal terms is an acceptance of that offer. So it's really important, if you're sent terms that you don't agree with, that you send even the merest holding email to say, thank you for your contract, we'll look at it in more detail, we don't agree with it. If you want us to start work, it won't be on the basis of your proposed terms. Then you can actually say, we're not accepting it. And even if we start work, that's not an acceptance of your offer. So it's really important, because silence, doing nothing in English law is not acceptance, but doing anything that relates to that contract can be acceptance. So it's really important to get your contract process right, particularly if you've been sent a contract you vehemently don't like and you just went, but if you then start doing work or ordering materials or going onto site, then the likelihood is that contract that you hated so much will be the basis on which you're working.
Okay, thanks, Sarah. Kevin's come back with a suggestion in relation to that question about defining reasonable quality. And he's suggesting, can you link a reasonable standard to something like the British standards, i.e. the tolerances in there, which seems like a good idea, doesn't it?
Yeah, absolutely. If you've got international standards, and assuming they're right, we did have a case where an international standard was wrong, quite an expensive case as well. However, for most of the kind of projects you do, we're not looking at brand new international standards. So if you can refer to those, then that's absolutely the best way to go. It's much clearer to both parties what you're trying to achieve, and they're good standards generally.
Okay. Great, thank you. So we've got one last question because we've been going for about 45 minutes now. So we'll squeeze in this one last question if we may, which is if additional works are instructed mid-contract and there are no defined schedules of rates, then how does the client know that they're getting value for money? Defined costs could be used. However, how does the client know that they're getting that value? And he's using the NEC option A, if that helps with that.
So the reality is, unless the client, and if there are no rates relating to the type of work being done, the client has no idea they're going to get a fair price until you either agree a price between the two of you or you have a price imposed upon you by the courts. So that's why it's really important to try and agree that price as you go. So change the price as you go. As every little bit of extra work comes in, you agree how much you're going to pay for it, because you did, generally speaking, under option A, and most of the contracts in the UK are lump sum contracts. We don't say, well, I'll do the walls and then I'll tell you how much the roof is going to cost. We agree the price of everything up front, because we're not interested in how much the different components cost. We're only interested in how much the whole project's going to cost. The same is true with changes. We would normally give a lump sum price. So therefore, that's what the client is looking for. Fair and reasonable, well, that's generally what the court will use as a basis for agreeing price. But if there are no rates, you should really come up with a mini proposal in the middle. So tell them how much it's going to cost, tell them the time, get them to accept it. Then that becomes an additional part of your contract. And use the same sort of good contract processes you would before the whole project for each of these little mini extras. I know it seems like a counsellor for perfection, but really the realistic view is if you don't use that sort of clear process, you're going to end up in dispute.
Okay, that's great. Thank you, Sarah. So I think it's about time that we draw the webinar proceedings to an end for today. One member has just asked a question as to whether they get a certificate for attending today's webinar, which is not something that we've done before. In fact, we've never been asked the question before, but it's an interesting idea because I guess this webinar could count as CPD. I don't know what purpose that member wants the certificate for, but we'll follow up separately about that afterwards. So it just remains for me to thank Sarah for all of her input today, which has been really helpful. And also thank you to all the members who've attended today, and also for your questions and comments as well, which has been great. Hope to see you all next time on Tuesday, the 17th of November. We've got the next legal webinar when Sarah will be talking about clarifying key outcomes and what's reasonable again, which has come up today, but also we'll be talking about that next time. So join us for that. We've got an additional webinar happening on Monday, November the 23rd, which is about Brexit. So you might have forgotten about Brexit with everything else that's going on, but it is still happening. So the webinar on the 23rd November is about how to prepare for the transition period, and we are expecting that might be impacts on construction material supply and that kind of thing. So we'll send out the link to that in the follow-up email as well. And then we've got another contracts webinar on Tuesday, the 1st of December, when we hope we'll all just be preparing to come out of lockdown. Fingers crossed. So thanks again for today. Thank you to everyone for attending, and stay safe and goodbye.